was a retired judicial official talking to me this morning because I thought that under theory that as we went along they created this system so that you had to work your way through it in order to get certain things. So the last time I got mad at the system, I went on my Facebook page and I was like, well, I think I could do almost like any job, right, in the political arena. Like you could vote me senator, congressional leader. I thought with a little help, guidance, I could even be a judicial official based on what I considered to be theory that I had gone through a couple courts. I went through district court where I had been in bankruptcy court and I denied it. I facilitated an action and then I backed out. I wanted to file bankruptcy and I learned chapter 5, chapter 13, and then I think bankruptcy. Some of these were business and then some of these were individual. And then as an individual, you had to, make a certain amount of debt in order to be considered in this group. So I had been through bankruptcy court, and then district court for me was criminal conciliation, and I had been through that. And then I felt like juvenile was something different under family, which as an individual you become a family. If you're not married, a guardian might have rights, or the parent, sole guardian, paternal, maternal. I learned these things, so I felt like I kind of weaseled my way through enough where I considered myself to be on certain people's level. So I solicited judicial official Peter Cahill, and I said, under the law, you created this system that said that I had the right to a public defender. And I had been through Rochelle Stratton, and I did not want her representing me. I felt like, as a public defender, she was arguing a case, but then not submitting evidence where she could file a counter motion and then force them to dismiss early based on the evidence that she submitted. And because she never submitted evidence, all she kept doing was forming this bogus ass argument and then telling me she couldn't get no evidence. And then, I tried to get the evidence for her. I thought about Joshua R. Williams, who kept saying, well, go get it because blah, blah, blah. So every time Josh sent me to get my own paperwork and he didn't do it, I didn't know what he did under his 144 hours, right? I started to backtrack in my mind the things I did aptly, and then I assigned them a title, like I was Josh's assistant, right? So then, as his assistant, and he was representing this dead Sharon, I was gathering her paperwork for him, and I didn't like that. So I went after Josh because I thought he violated his rights, and then I thought Rochelle Stratton, following in suit, was violating my rights. So then I had a problem with these pro bono attorneys. And the last time I went to court, I thought that they tried to get judicial official Lionel Norris this behind closed doors warrant where Rochelle Stratton might be able to say I'm crazy, right? I started calling her clunky clunk based on her shoes. Don't take it, personal, Bertha, because I did start calling her clunky clunk. I started calling Diana Wilkie part of the Michael Jackson program where, Dirty Diana and Clunky Clunk was fucking with me. And I thought Clunky Clunk and Dirty Diana had got this illegal warrant where they thought Access, after 5 years, probably needed to try medication, which violated my rights because None of my other doctors said I needed it. The only problem was that I came after these two white women as a black woman without a degree, proving, which I thought again, I was on their level. So I started filing these motions. And I thought Judicial Official Lionel Norris said I couldn't file these motions against these white women and make them recuse themselves from my case and give me new attorneys. And I had to write it out with Rochelle Stratton and Diana Wilkie. And as I wrote it out with Rochelle Stratton and Diana Wilkie, that's when I thought that they were violating my rights and tried to get this supervisor from Access to be a paid attorney where she was lying, thus dropping off marijuana, coffee, cigarettes, and my Mountain Dew, where I thought through the Food and Drug Administration they lied and tried to get an illegal medical directive in the Social Security Court where they felt like they were going to be able to medicate me. And then they did medicate me, which violated my rights. And the reason being is because I said they owed me money, right? When I went to this clinic where a Dr. Pickett, and I don't remember where Dr. Pickett resided from other than California. He's a black man with dreads. He came and he evaluated me. And he was like, Sharon, you know, all these tests I gave you, you came out like the average American. But my supervisor said that based on you saying. And what did you say, Sharon? I said, well, I told Dennis Maurer I was going to sue the state of Minnesota for my son, starting probably 3rd, 4th grade. And Dennis Maurer told me how hard it was going to be, so I thought it took through 12th grade for them to look back and then, you know, assign, you know, compensatory damages for the direct harm and then assign pain and suffering for the indirect harm that they had caused me and my children. So I put this dollar amount down, and this white woman with this other clunky clunk and Dirty Diana said Sharon's crazy. You know, even though I wrote it down like they would do. And just like they would do, I thought that I could go to school and be an attorney because I could understand some laws. I had did what I thought was my own Office of Adjudication appeal. I went through Social Security Court on my own, right, the first 18 months. And then after the 18 months, I started doing it on my own with the Office of Adjudication, which took almost another 18 months. And then I had to wait for a court date, which, you know, 2, 3, 4 years have gone by now, where Judge Quayle, you know, didn't want to assign me compensatory damages for what they owed me and even think about pain and suffering for withholding my Social Security from the car accident in 2004, which was expunged, by the way, through Joseph Kaminsky. I had Joseph Kaminsky expunge that accident because I said it was going to make my insurance go up as a black woman and it would be almost unaffordable to me. So I had the accident removed as I was fighting Social Security. But what Social Security said was, make sure you got your evidence. So I kept submitting the evidence of the car accident, the doctor's reports, what they were saying happened. And, you know, they just, through David Coker, right? David Coker's law firm was the one that said, you know, the doctor, which was Paris, said he didn't know what was wrong with you. But I highlighted on that one page, I denied disc fusion, right, Dr. Pinto? At 35, 34, I denied disc fusion. I was so young, and it was due to the car accident. They put me through a Social Security function test. You might not have found those records. Rochelle Stratton, Clunky Clunk, and Dirty Diana, you know, behavior, you know, and as I got drunk, you know, if you thought that's how you were going to get me, coming up with all these court dates, you'd be very clear, Judicial Official Peter Cahill. I thought I solicited you as a judicial official to send me a decision on why your system said that I could not pick my public defender based on some things. So I thought that for me, under the law, Freya Whitney would know that I was due a counterclaim and might be due some money, but under 50 hours, she might not have been able to do anything about it. But now that she's been within the system, she knows that you cannot discriminate and then intimidate lawyers like her, and then not get people like me fair compensatory damages as well as pain and suffering for the harm that you commit. So then therefore, to mitigate the state's liability and then deal with the citizen resident who has rights in the city and state of Minnesota, she should be able to make a deal. And then I solicited FOIA waiting to make that deal, and then still be able to do like I was told, which was not affirm nor deny, but you can mitigate damages to make sure that no one is saying we did or didn't do this action, but we're gonna, put it under the rug and move forward, which it's about 10 grand, or maybe FOIA wants at $5.50 an hour outside those 50 hours because she's no longer in school. She's not obligated to, act under the school. I'm not sure. That's why I asked. I was waiting for the decision. Did you get that out? Like fish whips. You give your baby a kiss with the fish whips. I'd be irritated.